The High Court to rule on the curious case of the GST Qantas customers paid, but Qantas never passed on, while the court begins hearing a case that could be vital for our free speech. Hello everybody, we're expecting a ruling in the High Court on an unusual case today. For more than a decade, we've all paid the goods and services tax, assuming that the company we paid it to would pass that tax on to the government. Usually they have. Well, Qantas collected $34 million in GST on airline tickets that travellers bought but never used. They didn't turn up, changed their plans or whatever. The airline didn't refund the tax, but it didn't pass it on to the government either.
Qantas is trying to have it both ways. Qantas is saying, we didn't provide a service, therefore we don't need to hand over the goods and services tax, which we have collected. But it's saying to its customers, we don't need to give you a refund because a transaction was complete. There must have been some sort of service. Now, Qantas is opening the way, if it wins this case, if the High Court says today, look, you don't have to hand over the GST, there was no service, it's potentially opening the way for a class action on behalf of its customers who will have a High Court judgment saying Qantas hasn't provided them with a service for which they've paid and paid GST.
Not just their customers. What about all the other businesses that took payment for services that weren't delivered and then actually passed the tax on to the government? How would they feel?
It'd be fair to say that the other organisations will be looking at this with considerable interest.
Also beginning in the High Court today, a case about just when and where a government can limit us from exercising our free speech.
Two Adelaide brothers have challenged a Adelaide bylaw which says that you need a permit to preach in the Rundle Mall. The South Australian Supreme Court found that breached implied freedoms of political communication in the Constitution. The South Australian government is now appealing to the High Court to have that decision set aside. So the High Court will be hearing arguments about whether this Adelaide bylaw, which says that you need a permit to preach in the mall, whether that's invalid because it breaches implied constitutional protections of free speech.
And when the High Court does rule on this, likely in a couple of months, it may just set some boundaries on the circumstances in which governments can limit our free speech. Have a good day today. See you later.